Tēnā koutou, tēnā koutou, tēnā koutou katoa. For those of you who don't know me, my name's Wayne Rumbles, I'm the Dean of Law. It is with great pleasure that I welcome you here to Te Whare o Waikato for the New Zealand Law Foundation Distinguished Visiting Fellows Public Lecture for 2018. I welcome members of the judiciary, members of the profession, current and past students, and members of Te Piringa faculty and the university, and visitors. I extend the welcome on behalf of the Law Foundation, the University of Waikato, and Te Piringa Faculty of Law. The Law Foundation Distinguished Visiting Fellow Program has been running since 1998. It brings leading international academics and judicial expertise to all 6 law faculties. It is not only for benefit of the faculty, staff and students, but it gives us another opportunity to reach and connect with the wider legal community. As a quirk of our semester break timing, we are fortunate to be the first law faculty that this year's Distinguishing Visiting Fellow has visited. It is my privilege to introduce Professor Tim Mccormack. Tim is Dean of the Faculty of Law at the University of Tasmania, recently moved from the University of Melbourne after 28 years to return to where he spent his childhood in Tasmania, swimming at the West Beach and playing footy at Emu Bay rail yards. Yeah, I've done my Google searches. Since then, he has had many significant appointments in the area of his expertise in international humanitarian law and international criminal law. And I'll just highlight a few, and they are just a few of his many. He's Special Advisor to the International Humanitarian Law to the Prosecutor of the International Criminal Court in The Hague. He was International Observer for Phase 2 of the Government of Israel's Commission of Inquiry into Israel's processes for the investigation of alleged violations of international humanitarian law. He was advisor on the law of war for the defence of David Hicks before the US Military Commission at Guantanamo Bay. He's been an advisor on the international law issues to judges of the International Criminal Tribunal for the former Yugoslavia. He was the foundational director of the Asia Pacific Centre for Military Law, the foundational Australasian Red Cross Professor for International Humanitarian Law. Tim also works extensively with the aid sector. He's the director of World Vision Australia. He has worked with Red Cross for well over 20 years, acting as National Vice President for the Australian Red Cross, sitting on the Red Cross Advisory Committee on International Humanitarian Law, and he was awarded the Australasian Red Cross Medal for Outstanding Volunteer Service in 2001 and the Australian Red Cross Distinguished Service Medal. Tim's research and publication record speaks for itself. He has placed him as a leading scholar in international humanitarian law and international criminal law. And more recently, he is exploring legal issues which surround current and potential use of autonomous weapons and human enhancements in the military. So without further ado, I welcome Tim Mccormack to present his public lecture on chemical weapons and other atrocities, contrasting responses to the Syrian crisis. Tim, thank
you. Dean Rumbles, Justice Powell, other distinguished guests, ladies and gentlemen, let me also acknowledge or at least part of my family, my wife Karen, my son Diggory, who've come with me from Tasmania, and my dear friend, childhood friend, Annie Bosson and her son Luke. Annie just thinking about kicking the footy at Emu Bay Railway Yards. I don't know which website Dean Rumbles found that information, but that reminds me a lot of the childhood we shared together across the back fence. It's a huge honour for me to be appointed New Zealand Law Foundation Distinguished Visiting Fellow, the first Tasmanian to ever receive that honour, and the third appointee from an Australian law school. And I'm really grateful to those of you present in the room who participated in Dean Rumble's egalitarian approach, democratic approach to the selection of tonight's topic. My responsibility was to provide a minimum of 3 abstracts of potential topics. I think I probably went above and beyond and provided 5 options, and it was your job, or those of you involved in the process, to select the one you wanted to have as this public lecture. So I'm really pleased that the choice is this challenging question of how the international community has responded to the use of chemical weapons in Syria, in contrast to how it hasn't responded to many, many other atrocities, and what all of that means for international law generally. Of course, what it means for the Syrian people is far more important than what it might mean academically in terms of international law, and I'll take a couple of opportunities to remind myself and all of us about the devastating impact of this incredibly complex crisis that has engulfed and devastated the nation of Syria. This is a humanitarian catastrophe with devastating reverberant effects that now has entered its 8th year. It all kicked off in March 2011. It's hard to believe that already now we're well into 3 months into the 8th year of this conflict. The International Committee of the Red Cross described it in 2014 as the largest and most complex humanitarian crisis in the world with no end in sight, and that's proved to have been correct over the ensuing 4 years. The death toll from this series of conflicts in Syria is now well over 500,000 and climbing on a daily basis, tragically. The United Nations stopped counting in 2014, largely because they no longer had reliable access to the data to give them an accurate assessment of statistics. The Syrian Centre for Policy Research in 2015 estimated 470,000 people dead, 400,000 as a direct result of the conflict or the exchange of hostilities, another 70,000 from the collapse of the health system. That same centre says now the death toll is way over 500,000, perhaps approaching closer to 600,000, and they have also stopped counting because their contacts on the ground are no longer able to access reliable data. Whatever the precise death toll, it's staggering. It's pushing close to 3% of the population of Syria, 22 million pre-war. If we were to translate that in per capita terms to New Zealand's population of just under 4.8 million, we'd be talking about over 144,000 deaths in this country. Imagine it. Imagine the consequences of that for all of us in the room. We would all know somebody who'd lost their life if it wasn't one of our own family members. In Syria, more than 5.6 million people have fled the country. It's the largest refugee crisis since World War II. They've spilled over the borders of neighbouring Turkey, Lebanon, Jordan and Iraq, and in each of those countries created a humanitarian catastrophe with how to provide basic or essential needs for life and survival. In addition to those pushing now 6 million Syrians, an additional 6.1 million are displaced internally within Syria. That means their homes been destroyed and they cannot any longer live in their own homes. And 13.1 million, the estimate is, 13.1 million Syrians are in need of emergency humanitarian assistance. You combine that's internally within the country. Combine that with the 5.6 million refugees outside the country, and we're talking about 90% of the country's pre-war population incapable of providing a decent living for themselves. The economy is in tatters, production is ruined, agricultural production, manufacturing, all ruined. Huge numbers of the Syrian population have been dragged into abject poverty. Government services are in abeyance, formal education doesn't exist anymore, and health services are completely overrun and inadequate. All of this tragedy that's happened in Syria started off, some of you will remember, back in March 2011 with the Arab Spring, the so-called, that was a term coined by the Western media to describe the succession of popular uprisings across the Arab world, which promised so much in terms of a new era of liberalism, human rights and democratic participation in government across a number of previous dictatorships. We think back to those heady days of March, April, May, June 2011 and the promise that this the series of popular uprisings held out, and what a trail of devastation it has been. The response of Bashar al-Assad in Syria was withering and overwhelming. The al-Assads are used to putting down popular insurrectionist movements. Bashar al-Assad's father Hafez in 1982 sealed off the town of Hama, where Muslim Brotherhood had its origins and had begun to foment a popular uprising against the regime of Hafez al-Assad. Sealed off the town, took all the media out, took all the humanitarian aid agencies out and smashed the city. And the estimates are between 20 and 40,000 residents of Hama lost their lives in 1982 as a consequence of that brutal crackdown. The son of Hafez al-Assad did what al-Assads do when the popular uprising commenced in Syria in 2011. Tried to shove all the media out of the place, get rid of all the humanitarian NGOs and go in and absolutely smash the joint. The difference was, this time around, it was a popular uprising across multiple cities in Syria, and this time around, social media enabled the capturing of live video footage uploading onto YouTube almost in real time of what was happening, and the world was far more aware of the extent of the carnage. I'm intrigued as an international lawyer by the contrast in responses by the international community on one hand to allegations and confirmed use of chemical weapons, and on the other hand with all the other incredible atrocities in scale and in devastating effect. I'm interested in three questions that I'd like to try and address tonight. First of all, what were the disparate responses? How has the international community responded differently in relation to chemical weapons versus everything else? Why has that response been so disparate? And what are the emergent implications for international law? But as I suggested right at the start of this presentation, whatever issues might intrigue us from an international legal point of view, the people who have suffered the most are the population of Syria, who have watched their country dissolve. And that is tragic for them, and I don't want to pretend that whatever else we talk about, we ignore all of that. So let's just start with 30 seconds of silence in acknowledgement of the devastation of that once great country. I'll regain myself and we'll move on through these questions that I'm asking. Let me start with responses of the international community to the confirmed use of chemical weapons in Syria. When the Syrian crisis first started spiralling out of control, concerns were expressed then about Syria's chemical weapons stockpile and the possible use of chemical weapons. There was concern about the possible use of them by the al-Assad regime. There was also concern about the possibility of them falling into the hands of ISIS or other terrorist organisations and them using them in the way that we have become accustomed to them having no sense of any obligation about exercise of constraint in the way that they conduct their operations. On the 20th of August 2012, President Obama made his famous red line speech in Washington, DC. I mean, isn't it nostalgic thinking about President Obama as the President of the United States of America? We cannot have a situation where chemical or biological weapons are falling into the hands of the wrong people. A red line for us is if we start seeing a whole bunch of chemical weapons moving around and being utilised. That would change my calculus, that would change my equation. Famous red line speech, and all of a sudden there was speculation around the international community about what President Obama might do if there was any alleged use of chemical weapons. Didn't take very long, just a few short months, 7 months to the day, on the 20th of March 2013, when there were allegations of multiple uses of chlorine gas in suburbs of Aleppo and also in suburbs of Damascus. And those allegations were followed in fairly quick succession, 24th of March in the city of Adra, then also into April in a number of other suburbs, Sheikh Maqsood and Sarakeb, suburbs of Damascus. On the 21st of March, so after that first day of allegations of chemical weapon use in Aleppo and in Damascus, the government of Bashar al-Assad asked the United Nations Secretary General to launch an official investigation under the auspices of a special mechanism that the UN Secretary General had established in 1987, a special mechanism for investigating allegations of chemical weapons. The mechanism was put in place in the aftermath of the extensive use of chemical weapons by Saddam Hussein's regime against Iranian soldiers throughout the 1980s, even before the shocking use of nerve gas in Halabja in the Kurdistan area of northern Iraq in 1988. On the 18th of August, so a few months after this request for the UN Secretary General to do something, the UN Secretary General's investigative team arrived in Damascus, and they were establishing themselves, getting ready to go off and investigate the allegations in these various places. They had not been in the country for 3 days, and just a few short kilometres away from their hotel, there was a massive use of sarin gas. At the time, we weren't exactly sure what substance had been used, hadn't been confirmed, but on the 21st of August, in the Damascus suburb of Ghouta, there was extensive exposure to some nerve agent, it seemed like, because of the symptoms that people demonstrated. Some of you might remember the images that went broadcast around the world, capturing the global media's attention with images of victims struggling to breathe, of experiencing revulsions, frothing at the mouth, overcrowded and makeshift hospitals, and row after row of dead bodies covered in sheets, many of them very, very small bodies, indicating children as victims. There was a torrent of condemnation that followed from the Ghouta attack, and the US Secretary General's investigative team rightly turned their attention to that specific incident. 3 weeks later, on the 13th of September 2013, the investigative team reported on the Ghouta attack to the UN Secretary General and confirmed that the nerve agent sarin had been used in surface-to-surface rockets, and that there were many civilian casualties at the time. The estimates were between 1,300 and 1,600. We subsequently have discovered that 2,000 people died as a consequence of exposure to sarin on that particular day. The Secretary General of the UN was scathing in response to those findings. He described this as a war crime, a grave violation of the 1925 Geneva Protocol prohibiting the use of chemical weapons in warfare, and claimed that the international community has a moral responsibility to hold perpetrators accountable and to ensure that chemical weapons do not re-emerge as an instrument of warfare. At the time that that report came out, or even in between when the investigators commenced their investigation and before the report came out, there was a great deal of international media speculation about whether President Obama will come good on his red line statement and actually intervene militarily. Between the Ghouta attack and the release of the report, it had become clear, I don't know who leaked the information, but it became clear in the international media that the investigative team had discovered incontrovertible evidence of chemical weapons use. And there was also some speculation that President Assad might be named as the party responsible. Just a few days before the release of the report on the 13th of September, on the 9th of September at a press conference in London, the US Secretary of State John Kerry said that President Assad had 1 week to hand over his entire stockpile of chemical weapons to prevent a US attack on his country. Sounded like threatening words, but actually that is exactly what happened. Because on the day before the report was released by the UN Secretary General, President Assad announced that he was signing Syria up to the Chemical Weapons Convention, and his instrument of accession to that treaty was deposited at UN headquarters on that day, the 12th of September. After the report was released, the United Nations, in collaboration with the Organisation for the Prohibition of Chemical Weapons, headquartered in The Hague, the multilateral treaty body that monitors adherence to and compliance with the Chemical Weapons Convention, established a joint mission for the elimination of Syrian chemical weapons. And they did their work between October 2013 and September 2014 to oversee the destruction of all President Assad's declared chemical weapons production facilities and stockpile of chemical agents. But well before the completion of that joint mission's work, so throughout the rest of 2013 and into 2014, there were a succession of allegations of the use of chlorine gas in the context of hostilities around the country. In response to those new allegations, the Organisation for the Prohibition of Chemical Weapons established a fact-finding mission. It went beyond the task force set up to oversee the destruction of chemical production facilities and chemical weapon stockpiles to actually investigate and confirm or deny evidence of alleged ongoing use of chemical weapons. There were more alleged chlorine gas attacks throughout the rest of 2014 and into 2015. And in frustration with the fact-finding mission's limited mandate, the UN Security Council adopted a resolution authorising the OPCW and the UN to give to the investigative mechanism the power not just to confirm the alleged use of chemical weapons, but to start naming those responsible for doing it. And so we had the fact-finding mission transformed into a joint investigative mission, and they started to investigate these various incidents. By 2016, early in 2016, they were naming the Assad regime and also ISIS as responsible respectively for different attacks that had occurred in the case of the Syrian government regime, primarily with chlorine gas delivered by barrel bombs from helicopters or aircraft, and in the case of ISIS, at least one incident of sulphur mustard gas use delivered by artillery shells. The joint investigative mechanism continued to report throughout 2016. Every 3 months they would report to the UN Secretary General, and into 2017. But just before, in late 2017, just before the joint investigative mission was to report on a particular chemical weapons incident or attack in Khan Sakun, the UN Security Council met to extend the mandate of the Joint Investigative Mission for another year. And this time, Russia vetoed that resolution. This is September 2017. There are different ways of trying to critique what Russia was up to. Some people would, of course, allege that Russia was trying to protect al-Assad, their client regime, and themselves from possible investigation by the Joint Investigative Mission, which some would say was becoming increasingly effective in its ability to name and shame. Others would say, no, the US was politicising the process by wanting to renew the mandate of the Joint Investigative Mission before it reported on this particular incident in Khan Sakun, because it might be trying to paint the Russians in a poor light. And perhaps there's truth in both of those two possible critiques of why the Russians vetoed the resolution that they did. But we know that in April 2017, before it had got to this point, President Trump launched his 59 Tomahawk cruise missiles at the Syrian airfield in April of that year, which he said was in response to the chemical weapons attack, because even beautiful babies were cruelly murdered in this very barbarous attack. No child of God should ever suffer such horror. There's a lot of speculation about whether President Trump was trying to distance himself from the Obama regime and the reticence of the Obama regime to rush into lethal military attacks on Syria. He didn't hold back and characterised it this way. I struggle with his statement, no child of God should ever suffer such horror, not because I disagree with him, but because many other children of God suffered horrors in other ways. And somehow or other that didn't evoke the same sort of response. In April 2018, we know that there was another attack from the US, this time supported by the UK and also by France. Just after the US announced its intention to withdraw its forces from Syria, there was another big chemical weapons attack, this time in Douma, where 70 people were killed. And this time again, the US responded with a missile attack. This time they claimed not against an airfield, but against alleged production facilities of the Assad regime, and said, we will continue to do this until the Syrian regime stops its use of prohibited chemical agents. That's as detailed as I can be in terms of the time available about a response or multiple responses to the confirmed use of chemical weapons. Let's contrast that with other atrocities, and there unfortunately is a litany of them. This series of conflicts in Syria has been characterised by all sorts of atrocities, by the use of starvation as a method of warfare, the laying siege to cities, and refusing to allow any fresh food or medical supplies to go into the city, refusing to allow anyone to leave it, and starving the population into some sort of surrender. There have been intentional bombing of residential areas, heavily residential areas, including with high explosive rounds. There have been indiscriminate attacks using barrel bombs, using helicopter gunships. There's been a denial of humanitarian aid and assistance. There's been a deliberate targeting of hospitals because they are providing medical treatment to the opposing side. There's been sexual enslavement. There's been systematic rape in some parts of Syria. There have been mass detentions, torture, summary executions of people held in detention. There's been deliberate targeting of cultural property. There have been enforced disappearances on a massive scale. And none of those somehow or other evoke the same response as we've seen in relation to chemical weapons. It's wrong to say that there's been no response at all to other atrocities perpetrated in the Syrian crisis, because we know that in response to ISIS attacks, particularly from Syrian territory across the border into Iraq, the US, Australia, the UK, a number of other allied countries have joined in aerial bombing campaigns across the border from Iraq into Syria to target ISIS in Syrian territory without Syrian government approval. RAF, Royal Australian Air Force, that RAF doesn't mean the same thing here as it does where I come from. I understand that. The Royal Australian Air Force deployed 2 squadrons of F-18s as part of that aerial bombing campaign. That's a very serious response, but it was targeted specifically at ISIS targets, and with some military success, whatever we want to say about the humanitarian consequences of it. ISIS's ability to control physical territory in Syria has been dramatically reduced as a consequence of the targeting of ISIS forces. But apart from that, the response to all the other atrocities that are such characteristic features of this conflict have been limited. Not muted because there's been plenty of protest. Not ignored because there have been organisations that have set themselves up to try to collect evidence of any atrocity by any side to any of the conflicts in Syria in the hope of preserving that material for possible prosecutions of war crimes and crimes against humanity at some future stage. But the lack of substantive response has nothing to do with the lack of information, because we've been saturated, inundated with media reporting of the atrocities going on in Syria. And some of the images that have been broadcast around the world have shocked us. And one of the responses of NGOs and humanitarian workers on the ground in Syria is shock that we're shocked by those images, because what is it going to take for the rest of the international community to realise that the carnage has to stop and to do something to help them? They can't understand, they often say, what it would actually take to stop the carnage, and why the apparent indifference of the international community. So let me pose this question: why the difference? What is it about chemical weapons that has elicited or evoked such a response, in contrast to the lack of substantive response of anything like the same scale in relation to all the other atrocities that have gone on and on and on? In the attack on Ghouta, 2,000 people died. At that stage of the conflict, 100,000 at least Syrians had lost their lives from the fighting. What's the explanation? And there have been a couple of things that have been offered. First one is that chemical weapons evoke a particularly visceral response. Some interesting writing in the literature from psychologists who claim that these particular weapons represent a category of extreme weapons in terms of how we respond to their being used. Not against us, but as we watch some of the images of the consequences of the use of these weapons. But for me, I just can't accept that the explanation is fear and revulsion alone. There must be more to it than that, because there is so much else that's been perpetrated against the Syrian people that ought to elicit fear and revulsion on our parts. Another explanation, or perhaps a complementary explanation, is that chemical weapons have been subjected to a long-standing taboo, with international legal regulation dating back to 1899, the first Hague Peace Conference, when the use of chemical agents was prohibited in war. But there have been plenty of other long-standing taboos against either particular methods of warfare or particular means of carrying out hostilities, and plenty of those have been violated in this conflict. So again, I can't accept that that's the sole explanation or even the primary explanation. And I'm afraid I've become a bit cynical about why the reactions happened. It seems to me that it cannot be explained in terms of care and concern for all of God's children, the subject of attacks by chemical weapons. And that perhaps it has more to do with the fact that for once in this conflict, the US and Russia are actually in agreement, because both of them are states parties to the Chemical Weapons Convention. Both of them have foregone the right to possess chemical weapons, let alone to use them as an instrument of warfare. And here is a situation where they're being used regularly. And if we don't combine together to stop this happening, then it might become acceptable for not just parties to the conflict in Syria, but in other conflict situations, to acquire and start using chemical weapons regularly. And for me, I think that's the closest we can get to an adequate explanation of how we try to understand, unpack this disparity of substantive response. So what does all of this mean for international law? And let me finish up some comments with some observations, and then hopefully we'll have some time for questions and answers. If the guest speaker hasn't raved on too much, that'll be a question for you. First of all, there's been a lot of discussion about the strengthening of the legal prohibition on the use of chemical weapons, and there are arguments sort of you could make both ways on this. Some people would argue that it's a very important development that Syria, prior to signing up to the Chemical Weapons Convention, as a major possessor of chemical weapons, has now become a party to the legal regime prohibiting not just the use of chemical weapons, but the possession, stockpiling, manufacture, transfer, or other acquisition of importing of chemical weapons. But this is the first state party on whose physical territory chemical weapons have been used after it became a state party to the regime. So the argument against that analysis is that this is actually a terrible thing for the Chemical Weapons Convention. It might be better, it might have been better, for the sake of the preservation of the legal norm prohibiting the use of chemical weapons, if Syria had never become a state party to the convention. And then we could say this is an aberration because there is no applicable treaty prohibition in this particular armed conflict situation. So there's an argument about whether, having become a party to the convention, repeated violations of it undermine the very normative prohibition that we hope the treaty might encompass. The second implication for international law here is that global criminal justice has still got a long, long way to go. Because from my perspective as Special Advisor on War Crimes to the Prosecutor of the International Criminal Court, this is a conflict that by any measure should be subject to the jurisdiction of the International Criminal Court. And it is not. It's not because of the limitations that are built into the Rome Statute establishing the International Criminal Court as to the court's jurisdiction. Syria is not a state party to the Rome Statute, it's chosen not to become a state party, and as a consequence of that, the only way the court could exercise its jurisdiction over any of the atrocities that constitute serious violations of the Rome Statute in that country situation would be if the UN Security Council referred the situation to the prosecutor. Twice, France has attempted to do that, and both times Russia and China have vetoed that resolution. They have the authority to do that, and they have chosen to prevent the court exercising its jurisdiction. And for me, that is the quintessential example of the limitations to the current regime that we have in place for global criminal justice. The International Criminal Court, as much as I believe in the institution and think it's doing a really important job, it does not represent a system of comprehensive, systematic, impartial global criminal justice. And those of us who believe in the institution need also to acknowledge that limitation and to work towards a more comprehensive improvement over the current regime. Third observation, there are only four, you'd be pleased to know, so not too long to go. The third observation about implications for international law is that the doctrine, the emerging doctrine of responsibility to protect, has taken a massive hit in Syria. Some of you will know exactly what I'm talking about, and others of you will have no idea. So let me just try to briefly unpack it. The international community has developed a notion that in circumstances where civilians are being targeted, where egregious violations of international criminal law are being perpetrated, the primary responsibility to rectify that situation is with the sovereign nation state. But in circumstances where that state is unable or unwilling to actually protect its own civilian population, the international community has primary responsibility. And that should be exercised by the UN Security Council. But when the UN Security Council is precluded or prevented from doing that, usually by abuse of the veto power by one or other of the 5 permanent members of the Security Council, it falls to the rest of the international community to step in and to protect the lives of people who are suffering egregious human rights violations. Some people, I would put myself in this category, who are supporters of the concept, the doctrine of the responsibility to protect, thought we were making some progress in Libya in 2011, also a conflict arising out of the Arab Spring with a popular uprising in that country, when NATO intervened to undertake aerial bombing, an aerial bombing campaign against Libyan government targets to stop initially the slaughter of the civilian population of Benghazi, the second major city in Libya. And the Security Council resolution, which authorised all necessary means to stop that carnage, referred specifically, explicitly, to a responsibility on the part of the international community towards the civilian population of Benghazi. The heading in the UN Security Council resolution is responsibility to protect the civilian population. Well, we're making some progress finally. Well, Syria demonstrates how limited that progress was and continues to be, because the international community has been prevented from taking substantive action to protect the lives of the Syrian people. And if you were to do a Vox Populi poll in Syrian cities and towns, to the extent that there are still people living in them, and ask them in Arabic, what do you think of international law? What influence has it had here? Well, the response would be devastating, wouldn't it? International law, what could that possibly mean? As a constraining influence of what's happened here. That is not a joke, because the consequences are so terribly devastating. So the fourth observation and final one is this, that strict compliance with international humanitarian law, the law of armed conflict, may not be enough to protect civilian populations. Because even, I guess this is a real tough lesson for me. Spent the last 25 years of my professional academic career promoting understanding of and respect for international humanitarian law. But I have to concede that in the Syrian conflict, even when a party to one of the conflicts there has tried to comply absolutely with the limitations on how they are to conduct their military operations, mistakes have still occurred on a regular basis. Hospitals, military hospitals, civilian hospitals have been bombed inadvertently, and people inside them who are entitled to the protection of the law have been killed or wounded while they should be immune from attack. Even strict compliance with the law does not have a beneficial humanitarian effect on the people who are supposed to be protected by it. Martti Koskiniemi, the great Finnish scholar, writes about international law as the gentle civilizer of nations. It has not played that role in the Syrian crisis, and I think the Syrian people would be right to be very, very sceptical about its influence and efficacy. Thanks very much.
So we've got some time for some questions. There is. Just want to raise your hand and I'll bring the mic over.
What could be done to challenge that? Yeah, change it? Yeah, so I guess there's a couple of ways to respond to the question. The International Criminal Court was a new development. It was negotiated, the treaty was negotiated in Rome in 1998, so 20 years ago this month, the statute establishing the International Criminal Court was open for signature. It was when the president of the diplomatic conference banged his hammer onto his gavel and pronounced the adoption of the text of the statute for the creation of the world's first permanent international criminal court, the room erupted into spontaneous emotional outburst. Australia sits between Austria and Argentina in alphabetical order. Argentinians are on the table dancing, and the Austrian head of delegation was seen to crack a smile. Both things unusual experiences in multilateral negotiations, but both of them, in my view, expressions of appreciation by those particular delegations, as well as across the room, for the historic significance of what had just happened. Now, I would never try to deny that what occurred and the subsequent developments of the establishment of an international criminal court where individuals are being tried and held accountable for their alleged atrocities is a very, very significant breakthrough for the international community. Should be supported, should be encouraged, should be strengthened, and there are lots of ways that could happen. So New Zealand and Australia as states parties should be fully supportive of the independence of the court and its ability to do its job. Keep supporting the financial cost of undertaking the exercise, which is extensive. It pales into insignificance in terms of the cost of something like the conflict in Syria. But So I think it's really important for me to take a long-term perspective on this, not a 5 or 10 or 20-year perspective, but a 100-year perspective. I would say that in 2018, we can look back over the last 100 years, 1918, since the end of World War I, and ask ourselves a question as an international community: have we or have we not progressed the objective of global criminal justice? Unquestionably, we have. Very significant developments. But in 2118, when I'm well and truly past it, 100 years from now, I hope that a future audience could look back and say, have we or have we not progressed this project of global criminal justice? Because what we have at the moment, while a very significant improvement on what was not there in the past, is not good enough to deal with the challenges that confront it. So in terms of what we can specifically do, I think it's important to both attempt to support and strengthen the current mechanism, the International Criminal Court, but also to advocate for its improvement and its increased capacity to be able to deal with some other conflicts that at the moment it doesn't have authority to deal with. Thanks for the question, I appreciate it. Sorry I can't be more optimistic. Is this a Dorothy Dix, Nathan? After having dinner with you last night, you slimed me up for a really easy one or really hard one?
Yeah,
Project your voice.
Just on the back of that question in response to it, I was just wondering, to what extent are those ambitions to bolster and support the International Criminal Court constantly undermined until there is a wholesale change of design of the security council?
Yeah. So I might just repeat the question for the sake of anybody who missed it and the recording, because I suspect it didn't pick it up. Probably should have repeated your question too. Sorry, I didn't. So Nathan's question, following on from the earlier one, is to what extent are efforts to continue to strengthen or to further strengthen the existing structures of the International Criminal Court undermined by the way the Security Council is currently structured? And particularly the veto power over any Security Council resolution. And I guess, is that an accurate summation of the question? That's important. I'd answer that by saying that I think it's important that the Security Council has the authority to refer a non-state party to the prosecutor of the International Criminal Court. It's a very important power, and I wouldn't want to see it taken away. I would like to see the Security Council more consistent in the application of it. It frustrates me that China and Russia would continue to veto attempts to refer the Syrian situation, even though I understand why the Russians have a vested interest in ensuring that doesn't happen, because they're deployed, and they're not just deployed, there are many allegations of Russian war crimes and crimes against humanity perpetrated as part of their support for the regime of Bashar al-Assad. So I understand the reasons why that veto keeps happening every time the French try to push it through. But it's deeply frustrating to me, perhaps even more than the freedom that any of the 5 permanent members have to frustrate the work of the court in this way. Even more frustrating for me is the fact that twice the UN Security Council has referred situations involving non-states parties to the Rome Statute, so Darfur in Sudan and Libya. Neither of those two countries, Sudan nor Libya, are states parties to the statute of the court, and yet the Security Council in 2005 in relation to Darfur and 2011 in relation to Libya, respectively, referred both situations to the prosecutor. But that's all they did. And although their respective resolutions demand that those two nations cooperate with the court, the Security Council has done absolutely nothing to substantiate and follow up those two referrals. They could be putting enormous pressure on those countries that regularly host visits of Omar al-Bashir, the incumbent president of Sudan, who is an indicted war criminal. He's wanted for trial in The Hague. If the Security Council was half serious about following through on its referral to the prosecutor, it would put enormous pressure on those states that are continuing to host his visits, including South Africa. And they don't. In fact, I know that I had a student, trying to remember which institution, could have been the University of Melbourne in a master's program, who was on an internship at the New Zealand mission to the UN when New Zealand was a member of the Security Council, a non-permanent member of the Security Council. And he was told when Fatou Bensouda, the prosecutor of the International Criminal Court, was coming for a 6-monthly report to the Security Council members, you can go if you want, but it's the other members of the council don't take it seriously. Which, when he told me, I felt devastated. I mean, it's probably true. I'm sure it's true. But that's really discouraging. And for me, the Security Council members, if they're going to refer a situation, have to follow through with the fortitude and the resolve to ensure that that referral is effective. Otherwise, it's a waste of time. I mean, you'd almost be better off, the prosecutor almost be better off saying, no, stuff you. I don't want that referral because I know you're not going to do anything to make it happen in practical reality. That would be quite a statement. You know, after the last 2 times when you've done nothing, stuff the referral. I'm not even interested in it. It's a waste of resources on my part. To do all the investigative work, to issue the arrest warrants, and to see you sit back and do nothing to make it happen. Oh, that'd be a big statement. But I think that's more frustrating than the recurrent use of the veto power. That you can sort of explain in terms of vested national interest, however, whether we like that or not.
Thank you. First of all, I want to say I believe that have the chemical weapon in the Syria, but some attack may be the fake because the video from the white helmets and some organism from the Sweden and some journalists from the Canadian already prove that they make the fake video to prove that the Assad's government used the chemical weapon. So how do you think about this fake video will influence the responsibility of when we judge who used the chemical weapon?
Sure.
Thank you.
Thanks. I'll try to articulate or summarise the question again for the recording, and you tell me if you think I've done that accurately. It's important that I get the question right. So my understanding of the question is, what about the allegation that others than, there's 2 allegations actually. One is that other parties than the government of Bashar al-Assad are responsible for the use of chemical weapons to make it look like the Assad government is the one responsible. And the second allegation is that some of the portrayal of victims has been staged to make it look like a chemical weapons attack when in fact it hasn't been chemical weapons. And I think these 2 allegations are probably connected to each other. Is that an accurate summary of your question? Yeah. Okay, so let me try to answer it. I don't know if you noticed, but I tried to be really careful tonight to not make my own assumptions about who was responsible for particular attacks. I made references to allegations, specific allegations made by the UN investigative team, but I didn't make any of my own. And that's because I can't put my hand on my heart and say I believe that it was Bashar al-Assad himself who ordered these attacks. Now, I mean, there are a number of possible explanations. One is that he did order these attacks, but another explanation is that he didn't, and why on earth would he, when the UN investigative team is deployed to Damascus, and just a few days later an attack happens in one of the suburbs of Damascus to make it really easy for them, a big attack, really easy for them to go and investigate that. And one possible explanation, because the investigative team discovered that the rockets that were surface-to-surface rockets that carried the sarin gas to Ghouta, the suburb of Damascus, were Syrian government rockets. Now, I don't dispute any of the findings that sarin was used, that 2,000 people died from exposure to it, or that that particular gas was carried by surface-to-surface rockets that were part of the Syrian government arsenal. What I don't think we can say with absolute confidence is that Bashar al-Assad knew that was happening and ordered it to happen. Another possible explanation is that individuals within his own armed forces who are opposed to his rule wanted the US to intervene militarily and made the attack occur to look like it was his responsibility so that the Americans would come in and bomb heavily Syrian government targets. So because I can't discount that factual possibility, and in some people would argue that actually makes more sense, because otherwise Bashar al-Assad seems to be an irrational actor to have made these attacks occur right at the time when investigations are occurring. So I accept that there are some questions about the facts, and if the prosecutor of the International Criminal Court ever did get jurisdictional authority to investigate and possibly prosecute, she would need to be absolutely sure that she could prove the case beyond reasonable doubt against Bashar al-Assad or any senior member of his regime or military before she could issue the arrest warrant. And that would probably be a very challenging thing to do. So here, on the question of individual criminal responsibility, we have a different standard than we would for the doctrine of state responsibility in international law, because if Syrian government forces are responsible for the rocket attacks, from an international legal point of view, that makes Syria as a state responsible for that violation of international law. But individual criminal responsibility is altogether a different matter. Can the prosecutor prove the elements of each of the war crimes she wants to allege against this particular individual perpetrator beyond reasonable doubt? Very different standard of proof. Anna Marie and I can catch up tomorrow if you're really pressed for time. Although it'd be pity to deprive the audience of her question.
First, thank you very much for your lectures, and thanks for pointing out that people also die by other weapons aside of the chemical weapons. So, thank you. And I totally agree with you that international criminal law between 1918 and now is much better. But the Security Council is affecting it so much. It was a direct result of the Second World War to reform. So what we are seeing right now from the UN, it is what reformed after the Second World War. Right now, we see as in the Syrian war is a systematic failure of the UN, not just in the international criminal law. This war created so many aspects of systematic failure of the international community.
Yeah.
The refugees, the war, it's so many things, and it's like it failed on all aspects. It's like, of course, it tried to help, but it reached a limit, and it couldn't progress after that. What is the way, of course, to reform the UN or the Security Council as it is? I mean, how to take that pre-existing condition of the veto, because that's what holds it back. At the same time, giving the strength to be active. Yeah.
Yeah, thanks. So if I understand the question correctly, you're making the observation, first of all, that the conflicts in Syria are a direct result of the failure of the international community, a failure of the Security Council, a failure of the rest of the United Nations and the international community as a whole to respond in any substantive way to this litany of disasters. And that's an indictment on all the international community.
Symptom. It's like it tried to help, but it couldn't. It's like so many, suggestions in the Security Council was made, and the veto stopped it. So the international community, it's trying to help.
Yeah.
But there is.
Yeah. So the issue is about the Security Council abuse of the veto power, and the questions about how to reform that to enable the Security Council to act more effectively. Is that correct? Pleasure. Thanks for the question. But the answer is demoralising, because the right to exercise the veto power is ensconced in the UN Charter. And you can only amend, the UN Charter can only be amended by a decision of 2/3 of the majority of the General Assembly, which is the plenary body. Every state party, every member state of the UN has a vote in the General Assembly. But it also has to be approved by the Security Council. And that means that amendment of the Charter is itself subject to the exercise of the veto power. And not one of those 5 permanent members will relinquish that authority. So that is the political reality that we are now stuck with. And it's not going to change. I don't believe it'll change until the UN is replaced by some other organisation. And perhaps we're having a chat today at a faculty seminar in the law school. Perhaps what will drive a change to a new organisation might need to be existential threats to the survival of the planet that require cooperation on a level we haven't seen before. Because unless we face that, climate change may be a driver of that, I'm not sure. Maybe a technological revolution to automation might help drive that. I'm not sure what the drivers will be, but I suspect that until we as a global community understand that without cooperation with each other on unprecedented levels, we can't actually survive for future generations, that might be the driver that forces change, that removes the veto power, that brings a new order. I'm not sure, but I suspect that might be right. Yeah, maybe. It's the last word, Anna Marie. Not the last word, the last question. I get the last word. I've got to respond to it, presumably. Unless it's a statement, of course, I can just say I agree.
Thank you for your fantastic lecture. I think there are many law students and lawyers in the room this evening, and I think as law students and lawyers, when we're reviewing very technical rules, we can lose sight of what is at the very heart of that rule, and that's the protection of human beings. And I think you've captured very well the sheer turmoil and human suffering that is ongoing in Syria at the moment. And my question concerns the classification of this conflict. And there is ongoing debate because of the myriad of actors, both within and outside Syria, that have taken part in operations in Syria, from the US, Russia, and so on, ISIS that has fired, has operating within Syria, and as you mentioned, has fired rockets into Iraq, but also the myriad of militia forces in Syria. So ultimately the question is, well, is this an international armed conflict or a non-international armed conflict? Where does it sit within the current regulatory regime of the Geneva Conventions? There are arguments emerging in some circles that this conflict doesn't sit well within the Geneva Conventions. Mm-hmm. And if that's the case, have we reached a point that international humanitarian law is getting a little bit obsolete, or could customary law fill the gaps?
Yeah, great, thanks. I'm sure because the microphone was working, all that got captured, I hope so. But let me just start off with responding to the observation, Anna Marie, about the humanisation of the law. If there's one thing I hate, it's a person who calls themselves a human rights lawyer or an international humanitarian lawyer and treats people they believe beneath their status in life as second-class citizens. That is fundamental hypocrisy. And so as a person who calls themselves an international humanitarian lawyer, believe that it's really important for me to keep reminding myself about who we're talking about. And I'd go so far as to say that I even pray that I do not become inured to human suffering. Because I think that's one of the problems in Syria, in response to Syria, isn't it? It's so in your face, day after day after day, month after month, year after year, that we just become used to it. that somehow or other we convince ourselves of what we expect from those people. They just do horrible things to each other. Let us not become like that. I certainly want to ensure that I don't. So, yeah, thanks. Thanks for observing that. A few tears too, never worried me about a few tears in public. I never found that a problem personally. Other people maybe struggle, but there you go. You see what you get with me. On the subject of classification, I don't believe that the situation in Syria is a single armed conflict. I think there are multiple armed conflicts going on. And that to engage in the process, as we must do at the ICC, you know from your own experience there working with President Steiner, from the prosecutorial perspective, we have to be clear about, in relation to alleging war crimes against this particular individual, did it happen in the context of an international or a non-international armed conflict? Of course, for the non-international humanitarian lawyers in the room, this might seem like a completely ludicrous question, but given the structure of Article 8 of the Rome Statute, divided as it is into those war crimes applicable in an international armed conflict and those applicable in a non-international armed conflict, it's fundamental to the prosecutorial task that we identify the character of the conflict. If we were to gain jurisdiction, the court to gain jurisdiction in the Syrian situation, and I've tried to refer to it as the conflicts, plural, or the crisis, or the situation, because I don't believe it's a single armed conflict, then we'd need to know who was this individual engaged in fighting, who were they representing, who were they fighting against at the time of this alleged conduct, or misconduct, this war crime, to be able to say, did this happen in an international armed conflict between Syrian government forces supported by Russia against Turkey, shooting down of a Syrian aircraft over Turkish, or Russian aircraft over Turkish territory? That's an international armed conflict. Or was it against the Kurds in Syria, in which case it's a non-international armed conflict? Was it against ISIS? It's a non-international armed conflict. So I think we'd have to, I mean, there are I think the best analysis I've seen on characterisation of the conflicts in Syria is by Terry Gill of Utrecht University Law School in the Netherlands. He published a really excellent article trying to unpack the legal character of the different conflicts in Syria, who's fighting against who and what, were they states or they non-state armed groups, in the symposium issue on the Syrian crisis in International Law Studies, the online journal of the US Naval War College. My article on this topic of tonight's lecture is also in that symposium issue. Although, as I was saying to Nathan on the way down here, I've written about it, but I've never spoken publicly. So it's a real privilege to be able to talk about the topic tonight. Thanks very much.
Just got one more.
Oh, okay.
Question.
Sure. I'm up for it if you are.
Professor, thank you for your empathy for the Syrian people. For sure, right now, there's a lot of apprehension within the ground.
A lot of apprehension about what?
A lot of apprehension about being in Syria. There's a lot of bullying happening there. There's a lot of things that's not coming out. I just spent a year there and came out. This is why I can say that. Do you think somehow the international community is stunted in its interest, in its investment in this crisis, and the fact that this Syrian crisis has gone for so long? Is it a failure of the UN? Is it a failure of the Security Council, do you think?
Yeah, I think it's a failure on every level by the Security Council of its responsibility to maintain and restore international peace and security. And of course we can explain that failure in terms of Russian vested interest. They're deployed there.